Noon. That's much better. Okay, this is the part of the program where I tell everybody to please silence their cell phones. You know how serious I am about that one. If you're new to the program and we want to continue getting updates on our upcoming programs, there is a mailing list box in the back. You can drop your email in there and you will send weekly updates on all of our upcoming programs. You can also use the back of it as comments if you want to tell us how great of a job we're doing or not. So I just have a few quick announcements here. Well, I don't know how quick they are, but they are announcements. Before we get started, next week at Lunch with Books, that's December 21st at noon, we're going to have our holiday program. Don Feenerty will be joining us for a second annual Simple Life holiday. If anybody knows Don, he's a fantastic storyteller, and this year he's written an original story that he's sharing with us. It's called The Christmas Ghost of Hart Road. And then he's going to showcase some simple crafts and gifts that anybody, he claims anybody, can make. These are based on the Firefox books that were written or compiled by former Wheeling resident Elliot Wigington. I almost said books there, but it's Elliot, his son. He's also going to be joined by Fair May as a musical guest. They do traditional Scotch-Irish songs. They're fantastic. They're very young kids, but very talented. So that is next week, December 21st at noon. The following 2 weeks, we're going to have two musical programs in a row. December 28th at noon, we'll have Eli Lambie with us. He's a music teacher at Marshall County Schools, but he's also a fantastic pianist. He's going to do some lesser-known anthems of West Virginia, including one that he's written himself. That's to prepare us for our first Lunch with Books program of 2022. That is Tuesday, January 4th. WVU English professor Dr. Sarah Morris and the troubadour Bob Gaudio will be with us to take on the most famous of West Virginia anthems of all time, John Denver's iconic and internationally ubiquitous Take Me Home Country Roads, which turned 50 years old this year. So that is the first program of 2022, January 4th, Tuesday at noon. This Thursday, December 16th at 7 p.m., we're continuing with our People's University Cold War series. We'll have with us Dr. Joe Laker, Emeritus Professor of History from Wheeling Jesuit University. He'll be talking about the fall of empires. This is the rise and fall of empires and the consequences of colonialism, both for the colonized and the colonizers. That's this Thursday at 7 p.m. Then the following week for Class 4, Dr. Hal Gorby will be with us, but that's not going to be on a Thursday. That's going to be our Tuesday program, or the only Tuesday in that series. So Tuesday, December 21st at 7 p.m. Dr. Gorby will be talking about the second Red Scare, so communism in the United States, or perceived communism in the United States. Both of those are 7 p.m. here in the auditorium. The first one is this coming Tuesday, December 16th. The following one, that next Tuesday, December 21st. All right. Today's guest is Anne Marie Lofaso, is the Arthur B. Hodges Professor of Law at West Virginia University College of Law. She teaches labor law, employment law, constitutional law, comparative and international work law, jurisprudence, law and socioeconomics, and also in the WVU U.S. Supreme Court Clinic, which she co-founded with Jones Day partner Larry Rosenberg in 2011. She was formerly the WVU Law Associate Dean for Faculty Research and Development from 2011 to 2015, and a Leadership Fellow in the WVU Office of the Associate Vice President for Creative and Scholarly Activities. She has previously taught at American University, Washington College of Law, the University of Oxford, and most importantly, right here at OSPL's People's University. You can watch all three of her summer of 2020 People's University lectures on the library's website. Just search for the Struggle for Women's Rights or on the People's University YouTube channel. Please give a warm welcome to Professor Mary, I don't know why I want to say that, Anne Marie Lofaso.
Thank you so much, Erin. Can everyone hear me? I just wanted to say I need to keep my mask on because my husband's immunosuppressed, so I'm actually very, very careful. I don't want you to think it's a political statement or anything like that. It's really for my husband's well-being. Also, I'm just so delighted to be here. I understand that Sean hasn't been feeling well, so I just want to say hello to Sean. I know he's watching, so I miss you. I thought I was going to get to see you today, so I'm sorry. But I always feel so welcome here, and I never miss an opportunity to come, and I'm so happy that Sean seems to be willing to invite me all the time. So that makes me very happy. I never say no when I'm invited here. So today we're going to talk about the Bill of Rights because tomorrow is the 230th anniversary of its ratification. I have to see if this is working. Hold on, slideshow. Here, there we go. Oh, and I just want to thank not just Sean, but there's so many other people that probably help with this, and I don't know their names, so I just want to thank all the invisible workers who made this presentation possible. So my lecture today is divided into 4 parts. First, we're going to define and provide examples of what is a Bill of Rights, and then I want to talk about the context leading up to the U.S. Bill of Rights. Then what are the liberties contained in the U.S. Constitution, but then what are the ones that weren't in there that we felt was necessary to put in a Bill of Rights? And then I'll briefly conclude and maybe have some discussion if there's time. So let's first start with defining a Bill of Rights. So a Bill of Rights is any document setting forth liberties of the people, typically in relation to a government. So a liberty is not necessarily a right. When you say a right in layperson's terms, we often think of them as the same thing, but actually in legal terms, a right is typically something that you can claim a duty from someone. So for example, if you have a constitutional right to something, then you can claim a duty on the government to do something, that they would have to affirmatively do something. Otherwise, it's a constitutional liberty, which is different. It just means the government is forbidden from acting, which are 2 different things. So let's just say, for example, if you have a property right, then you can actually, you have a right to keep people off your property, which means people have a duty to stay off of it. But if you just have a liberty to go on a piece of property, like an easement or a park, that means you just are free and the government or people are not going to let you not go on that property, which are 2 different things. So I just wanted to make sure you understood that technical distinction. So for the most part, liberties and sometimes rights, their liberties are definitely freedom from coercion. And like what I like to tell my students is that the government's the most coercive force in your life. Because the government, our government, which is one of the freest in the world, can still take your life, liberty, or property as long as it gives you due process of law. So just think of it. We actually have given our government the right, the power, it's not a right, the power and the authority to take our lives as long as they give us due process. In other words, capital punishment, which is pretty coercive. I would say the second most coercive power in your life is almost certainly, if you work outside the home, is your employer. And then from there you can go on. But it's not even usually close that the government would be the most coercive source in your life. So any document setting forth freedoms of the governed from governors is going to be a Bill of Rights. And we're fortunate because we have an 800-year history, of course, meaning coming from our Anglo roots, we have an 800-year history of putting sort of brakes on what could potentially be an even much more coercive power in our lives. So what I'm referring to is the Magna Carta. And the Magna Carta, sorry, that was my New York accent coming out. The Magna Carta is the first European written document of human freedom. And it limited the power of the crown primarily with respect to the barons. So it was really not meant for everyone. It was really meant to start to share power between the king and the lords. But it addressed more than just the barons' grievances. It addressed primarily the barons, but there was some talk about serfs and in respect to what their taxation would be, and some stuff about their labor, but it was primarily almost almost exclusively to the barons. It's a general statement of political reform. It also protected church rights, and it protected subjects from illegal imprisonment and disproportionate punishment, granted due process to subjects, promised access to swift justice, limited taxation and other feudal payments to the crown with certain forms of feudal taxation requiring the baron's consent, and it was reaffirmed between 3 and 4 dozen times over the next 2 centuries. So that's 1215. So even in the first 200 years of its existence, it's actually reaffirmed constantly, although sometimes rights were taken back, so it wasn't like a linear progress. But this, you can imagine when you have a king or queen who's so powerful, getting a king to concede or to cede some of his authority is a really big deal and an important precedent. So after the English had their Civil War, and then later on, the English have this Bill of Rights in 1689, and in that, this is William and Mary, and the King and Queen. Also, my daughter is about to go to William and Mary College, so I wanted to put that up there. But they were the King and Queen at the time, and they said this Bill of Rights gives freedom to elect members of Parliament without royal interference, freedom of speech in Parliament, freedom from royal interference with the law, freedom to petition the King and Queen, freedom to bear arms for self-defense, specifically for self-defense, freedom from cruel and unusual punishment and excessive bail, freedom from taxation by royal prerogative without the agreement of Parliament, so no taxation without representation, freedom of fines and forfeitures without a trial, freedom from armies being raised during peace times. And then this is another interesting one. In 1701, the Act of Settlement comes in, and it removes Catholics from the succession to the crown. So you have to remember, this is coming in at the end of the Reformation, and there is obviously a bloody history starting with Elizabeth and Mary, and eventually, though of course King Henry is credited with breaking from the Roman Catholic Church and making it the Church of England, himself the head of the church by the Church of England. This is very clear by 1701 and is even put into law. So there's I think also, if you didn't know this, Tony Blair is now a Catholic, but at the time he was Prime Minister, he was Anglican, because you can't be Prime Minister in England if you're a Catholic. So I say that is pretty interesting, because with all of these freedoms, there's something that we would find written into the law intolerable, to say that that there may be prejudice in this country, but we wouldn't want that in the law, even if it's unusual for us to have. We've only had 2 Catholic presidents ourselves, so, and no other religion. Okay, so let's go on to the next part, which is the context leading up to the United States Bill of Rights. And in this part, I'm going to divide into several parts too: the Age of Enlightenment of the 17th and 18th centuries, colonial self-identity and disunity, then the French and Indian War, and the bankruptcy or the financial pressures that war put on Great Britain, and then increased radicalization of the colonists and increased violence, and leading to a more unified identity, and then the war of the granting of American independence, but the failure of the Articles of Confederation. I'm going to zip through this pretty quickly, just to remind everyone about your American history. So I'm only going to, for the purposes of the Age of Enlightenment, I'm only going to focus on John Locke, because I could teach, a whole course on the Age of Enlightenment. But some important concepts that I want to talk about are natural law, natural rights, and the social contract theory. So natural law is the idea that certain laws apply to all humans regardless of place or time. Now, when I teach jurisprudence and when I talk to my students, most students do not believe in this. They believe that rights are granted by a government. But there are some people that think that certain laws apply to all humans regardless of place or time. I'm one of them, actually. But I recognize that they are not always recognized by the government. So I make that distinction. But you're welcome to have, as I always tell my students, there's no right or wrong answer to that question, whether there are natural rights or natural laws. But these laws are discoverable by reason, not by divine intervention. So they would be separate from revelation. So people of this time period were very religious. People of this time period are less religious than they were this time in the Enlightenment. And they said that these are different things. So God might reveal in the Ten Commandments in the Old Testament, if your God is the Abrahamic God, or in the New Testament, that would be obviously important. But the idea here is that God reveals those things because people wouldn't be able to come to those conclusions necessarily by reason alone. So God needs to reveal himself through the Bible. But there's other rules that you can figure out just through reason. And they do overlap, and divine law might be stricter, but it can't be contrary to these laws of nature, these natural laws. Their people are by nature free and equal, according to Locke. Now, there's other theorists during this time that have different thoughts. I'm not going to talk about them because we really are a Lockean nation as opposed to Hobbesian or Rousseauian. So you've heard those are the three big ones, Rousseau, Locke, and Hobbes. But we really follow, in terms of our precedents, really Locke. But among those rights are the right to life, liberty, and property. And the use of the term right here is much more in line with what I talked to you earlier about, this idea of freedom. So social contract theory is that government exists to protect the rights of people and promote the general welfare, and the government should have no say on people's religious beliefs. So there's the idea of separation of church and state coming in. There's other things with social contract theory, but I'll suffice it to say that the idea here is that in the state of nature, whether that's a hypothetical, like a theoretical state that doesn't really exist, or that we really could trace back our history and there is really a state of nature before government, that we agreed to give up a certain amount of liberty and have this coercive power over us, government, but in exchange, we're safer and therefore we're more free. So the idea is that that we're founded on, that Britain is founded on, is that, okay, fine, we will come together in a society. We have to have rules to do that, but you're making us safer, and that's why it's legitimate to do those things. That's why laws are coercive. If humans are by nature free and laws are coercive, then why can't we just anytime overthrow the government? And the reason is because if the government is legitimate, then the government is allowed to have a certain amount of coercion over our lives because it's making our lives better. So that's the theory in a nutshell. Okay. So before the French and Indian War, colonists saw themselves more as rivals. So there'd be New Yorkers, and there would be Virginians, and there would be South Carolinians, and they were sort of economic rivals. But after the war, they started to increasingly unify. Now, the Albany Plan was established by Benjamin Franklin, who proposed an intercolonial government to tax, make laws, and provide for the common defense. But it failed, showing that really around the time of the French and Indian War was just too early for colonists to see that they had common cause and that they should band together to make common cause, to be stronger. But as you can see that after the French and Indian War, after the French, I don't have the graph for this, but I can get you this. You can get this off the web. The national debt of Great Britain nearly doubles. Okay, because of that, and because so much of it was done in their belief to protect the colonists, they wanted the colonists to pay. So you have the Sugar Act, the Currency Act. The Currency Act was terrible from the colonist perspective because all this paper money they had they no longer were allowed to use. And so they couldn't pay their debts with it. So it was the colonists were suffering. The Stamp Act, so they would have to pay for these stamps. The Quartering Act is not cash. It's not about cash, but it's about quartering soldiers, housing soldiers in your home. And so obviously that would be a burden on you because you'd be feeding them, you'd be giving them blankets and beds and things like that. And the Townsend Acts and the Intolerable Acts, these are all pretty much taxes. From the British point of view, this was necessary in order to keep the colonists safe. They poured money into this. The colonists said, but we're not represented in Parliament. We are Englishmen, and we should have the rights of Englishmen. So this is increasingly, this is something that people are upset about. Now, the no taxation without representation movement starts in the first time it's used is in a sermon by John Mayhew, and it's a pretty common phrase, and it's popularized in the 50s and 60s of the 18th century. But what we can see is on top of this, if I could put these together, you'd see on top of it are all these taxes that people are upset about, the Quartering Act. And at the same time, there's increased violence, and so there's radicalization of people that are upset with the government, feeling we don't have any representation, so we have no say over how you're governing us. So you have the Boston Massacre, as you may recall from your elementary school days, and the Boston Tea Party. But after the Boston Tea Party, there's a series of acts called the Intolerable Acts, which is the Boston Port Act closes the Boston Harbor. Okay, so it means nothing can come in and out of Boston, which is really, as you can imagine, if you have an embargo, this is economic warfare. The government, the administration of the Massachusetts Government Act, Administration of Justice Act. So these laws were also saying that there's no self-governance anymore in Massachusetts. So it was directly that the king was essentially ruling. And then, of course, another Quartering Act. So the colonists came together and helped Boston in 1774. They brought aid to Boston to help them. A response to all of this is the First Continental Congress. And then you have the battles of Lexington and Concord. There's also some skirmishes before that, but that's really the first battle of the Revolutionary War. And then in response to that, just 3 weeks later, I think it is, it's April 19th, I think it's like May 7th, you have the Second Continental Congress, which ultimately is the one where Jefferson and his crew write the Declaration of Independence, okay? So what you see here is increased radicalization, and I don't say that in a pejorative way. I say that in a way that, can you imagine like how much it takes for someone to actually take up violence against their government, what they have to be thinking, and they have to be believing that to take up violence against the government. Okay, so now during this time, the Second Continental Congress sets up the Articles of Confederation, which are drafted between 1776 and 1777, the end of 1777. And it's ratified by all 13 colonies. It had to be in order to be put in. It had to be unified. And the congressional ratification then comes shortly thereafter on March 1st, 1781. This established a unilateral legislature, and those of you who've heard me speak before, I've talked about this, all the weaknesses of it. It's very, very weak. Obviously, the colonists are very skeptical of any kind of strong power. They're coming off of King George, who they thought was corrupt and inept. History can tell you whatever those are. I'm just giving you what their thoughts are, or at least some of their thoughts. Remember, the Revolutionary War is not a unified war, of course. There were royalists as well as non-royalists. But eventually, the Treaty of Paris is signed while under the Articles of Confederation. And what the United States figures out very quickly is this isn't working. Because how can it work if we don't have a president, not a king, right? They don't want a king, but we don't have executive powers, we don't have a judiciary, we don't have a tax base. Just those alone. So how is this going to work out to do anything? So we have the Constitutional Convention, and the thing that I'm not going to stress today is that the first thing that the Constitution does is establish a government. So if you look at Article 1, it establishes the bicameral legislature. Article 2, the executive branch, which is the president. Article 3 is the judiciary. So separation of powers, the supremacy clause of the federal law over state law. Okay, how to ratify this. So the Constitution is primarily just establishing a federal government. Now note, there's already state governments. So every state has some sort of government. But this is a federal government that would have different powers. So this brings us to liberties contained in that US Constitution itself. Now I just stated that it's primarily establishing a government, but even in establishing government, there are several liberties within the Constitution. I'm not talking about the Bill of Rights. This is not the Bill of Rights. So let's look at them. Article 1, Section 9 contains several. It prohibits titles of nobility. So that's why Meghan Markle cannot, if she has any kind of title from England, she cannot be a US citizen. She'd have to give that up. She can't be, you can't, like, so before Prince Andrew, I'm sorry, she's married to, is it Andrew? Harry, sorry. Harry, yeah, we don't want to talk about Andrew. Okay, so Prince Harry can't be prince and be an American citizen. You cannot be royalty and be an American citizen. It's unconstitutional. It's in the Constitution. It prohibits Congress or states from passing bills of attainder or ex post facto laws. So that means that a bill of attainder is you just can be put in jail without trial. And ex post facto law says that today this is a civil, this is not a crime, or it's some sort of civil thing, but not a crime. Tomorrow we make it a crime, but the act you did yesterday, we're going to apply it retroactively, even though it wasn't a crime. So let's say everyone was driving 60 miles an hour today. Tomorrow we say anything that's over 50 miles per hour is a crime, punishable by 2 years in prison. And they have you on their radar who was going over 50 miles per hour from yesterday, you would all go to jail. That's a bill of attainder. That's an ex post facto law. That is unconstitutional. And that is literally in the Constitution, not even the Bill of Rights. It prohibits, writs of habeas corpus may never be suspended except where there's rebellion. So the only time it has been allowed, although others have tried to do this, was Lincoln did suspend writs of habeas corpus. A writ of habeas corpus just says that you have to bring the body, the corpus, meaning the prisoner, to the court and tell the prisoner why are you here, and give them a trial. And also, it could also be a writ of habeas corpus. Could also be, I think that the state government or the federal government violated my constitutional rights. Even though I was found guilty, my rights were violated. So I am entitled to the federal government to look and reassess my guilt. Okay, so let's say, I always say, you might disagree with me on this, but I always say like that O.J. Simpson was framed, but they framed a guilty man. Okay, and so let's say he was found guilty by the jury, which we all know he wasn't. But if he was, he would have had a really good argument to say that, well, they Furman planted evidence, so I didn't get a fair trial. And so now we all know what happened with him. He actually was found not guilty. And then he committed other crimes, so he was put in jail for those other crimes. But I always say they framed a guilty man and they should have just let it go. But again, you can disagree with me on that, but we'll never know the truth of that. Okay, so the other ones are, the states can't impair your obligations of contracts, okay? That's like a very technical one that most people don't go deal with. In Article 3, Section 2, it guarantees a right to trial by jury in criminal cases. That's actually guaranteed in the statute. In the Constitution, the body of the Constitution. Article 4, Section 2, the citizens of each state are entitled to the privileges and immunities of the citizens of every other state. So that means just because I'm a West Virginian doesn't mean I can't be treated worse when I go to New York as if it's a different country. Okay? And then in Article 6, it prohibits a religious test or qualification for holding federal office. So you can't, which is, remember that Catholics can't hold certain offices in Great Britain or in the UK. And that we got rid of in the Constitution itself. So this is something that was obviously very important to the founding fathers. But it wasn't enough for some people. So this is where we're going to move to the Bill of Rights finally. And the author of the Bill of Rights is James Madison. And the purpose of the Bill of Rights was to satisfy opponents of the US Constitution who wanted to be more explicit about curbing government power and ensuring human liberties. So the idea was this very big concern that government is coercive. And they want to be able to curb the government, but at the same time they understood the government has to be able to act. So they have this experience with the Articles of Confederation. That didn't work. So it has to be strong enough, but also not coercive, not too coercive, right? It's going to be somewhat coercive. So everyone see the balance between those. So there were two camps. Obviously, it's really more of a spectrum, but you have the Federalists and the Anti-Federalists. And the Federalists supported the strong national government. So that would be someone like Hamilton, okay? And the Anti-Federalists wanted to keep power local. And that would be someone like Jefferson. Although Jefferson, when he became president, very conveniently became a Federalist. So I always say when you're in power, of course, you want as much power as possible. So you say one thing when you're not in power. When you're in power, you say something else. So Jefferson's really interesting in that. But we're not talking about Jefferson today. So what the Constitution needed was the Anti-Federalist support to ratify. So they wanted the Bill of Rights. So it was written. And there were many inspirations, but I'm going to talk about two. Mostly I'm going to talk about the Virginia Constitution and the accompanying Virginia Declaration of Rights, which was written by George Mason primarily. But I'm going to talk briefly about the Iroquois Confederacy as well. So the Virginia Declaration of Rights of 1776 actually is really interesting if you read it in its whole. It's pretty short, but I'm going to highlight some of the stuff that's in it. Section 1 says all men by nature all men are by nature equally free and independent and have certain inherent rights. Okay, so some of those rights are the enjoyment of life and liberty, a means of acquiring and possessing property, pursuing and obtaining happiness. Okay. That all power is vested in and consequently derived from the people. That no man is entitled to exclusive or separate emoluments. Remember that word was thrown around a lot. It's actually also in the Constitution. An emolument is a privilege of office. So it's like, just because you are in office doesn't mean you should get special privileges. And that was a really big debate. I don't know if you remember with Trump, was that he didn't divest, and every other president had divested himself of their property. So he was making money in his hotels by being president and having people come in. So many people believe that that's a violation of the Emoluments Clause, and that's something that goes way back to that period. That's why it was important. It is an important debate. I always thought that, and I still think that probably they will make that more clear. So if people are really upset about that, then maybe it should just be made more clear in the law. So, but anyway, I think that might happen. 6 is about free elections. 7 is about the power of suspending laws. It's a statement that if you suspend laws without the consent of the people, that is injurious to their rights and ought not to be exercised. 5 is the commitment to separation of powers. 8 talks about criminal and prosecution and capital prosecutions, which you have a right to demand the nature and cause of the accusation. That's like habeas corpus, but it's also Miranda rights, essentially, later on, to be confronted with your accusers, to call for evidence in your favor, to a speedy trial. I mean, you could read these and you could see where there's this precedence really in the Virginia Declaration of Rights. Excessive bail should not be required, nor excessive fines, nor cruel and unusual punishment. That is almost verbatim what is going to become the 8th Amendment. 10 says you need warrants for searches and seizures. 11 is trial by jury. 12 is freedom of the press, is really important. So people sometimes get upset because the press picks on the president, but I always say, oh no, that's the job of the press. The press right now should be picking on the president as much as possible, should pick on every president because that's their job. Now, we might have other problems with the press. We might think that some press picks on them more or less than others, and some But we should be much more upset when the press is apologizing for a president rather than picking on the president, because that literally is their job, is to make sure that the head of the most coercive force in your life is telling you the truth. This is interesting, I think, especially in West Virginia, is Section 13 is the Second Amendment, really. So well-regulated militia is important, and so safe defense of a free state. So the idea that people are trained in, it's really interesting too, because it talks about that people are trained in arms. We now have a lot of people who are not trained in arms, not so much in West Virginia, but in other states. And so it really makes, you think about the Second Amendment, and you think about that in some people's arms, it's actually pretty dangerous. I always say in West Virginia, people have guns because they like to hunt and it's recreational. In New York, when you have a gun, you're hunting people. And so it can be quite dangerous where I'm originally from, and it's very different here in West Virginia. But again, we could talk about that. Section 14 is the right to a uniform government. That means in Virginia itself, there wouldn't be multiple governments. So the state government is one thing, the federal government's different, but you have uniformity across the entire state. Section 16 is a commitment to the adherence of justice and certain values like moderation, temperance, frugality, and virtue, and then free exercise of religion. So I want to go through that because I think it's really important to see how much of that we have taken and where it comes from. So when recently there was a Second Amendment case, and there's going to be another one, and I'm going to tell you right now, a lot of it and how it's interpreted is coming from the Virginia Declaration. And one of the reasons I think we've had a more robust interpretation of the Second Amendment is precisely because this document says more about the right to bear arms than our own Constitution. And so the idea is, well, they must have influenced each other, so we can then import some of those values from the Virginia Declaration into our own US Constitution. Others disagree with that, but I'm just describing what I think the Supreme Court has been doing. Now, interestingly, Iroquois Nation also was very influential. They actually are probably the oldest democracy in the world. Now I had to, again, I'm from New York, so I'm actually from Manhattan and then Long Island, so which is all the way in the southern part of the state. But I had to learn about the Iroquois tribes. So I remember this very, very, very a lot, but I noticed in different states, because I've lived in so many different states, they teach different things. They teach about the Indians of your state. So a lot of people don't learn about the Iroquois that maybe are in the West, because the Iroquois are from this part of the world, of our country. But some people think that the democracy is as old as 1142, and there's a lot of evidence suggesting that. Some people think it's wasn't until 1451, but there's a lot of evidence, newly emerged evidence, that suggests several hundred years before that. And what they were doing, they were very warlike, and they wanted peace. So the idea was to bring these, originally it was 5 nations, but then the Tuscarora Nation came in later on. And the whole idea was to keep the peace and to settle disputes. I didn't put in all the language, but it's really very interesting if you see that they were really working together to have these grievances resolved. And many of the founding fathers understood this and had a lot of respect for their system of government. So I wanted to go through the 10 amendments very briefly and show, really talk about them, because when you look at the language, I always say to my students, blah, 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 because it doesn't say much, right? And then you really have to look at the case law to understand it, because it's not like you hear a lot about textualism in judges, and all judges are textualists now. It means they follow the letter of the law and look at it very carefully, and not what the purposes of, they only look at the purpose of a law if the letter of the law is unclear, and then they can try to figure it out. But the text of the Constitution is by definition unclear. It's just a directive, it's more of a principle. So there's a lot more room for interpretation, which is why on the Supreme Court, you could have varying interpretations, all of which are reasonable, but we disagree based on our own politics. So abortion is a really good example of that. where you could say, on the one hand, this interpretation of the due process would say that would allow abortion in certain circumstances. This one would allow it in all circumstances. This would never allow it. And they're all reasonable interpretations, and it becomes basically who's on the court for some of those things, okay? So let's just look at, like, for example, the First Amendment says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or the right of the people peacefully to assemble and to petition the government for redress of grievances. So I want to start with the first line to make a point. It only talks about Congress. Now, early on, that word was interpreted as the entire government, but it only says Congress, which means the president could, if it were interpreted differently, coerce your freedom of speech. A court could do that. It only says Congress. But very early on, the courts interpreted that as saying, no, that means any kind of government. And later on, it also meant state governments. So even if the state government doesn't have its own constitution, because remember, the First Amendment originally only applies to the federal government. You have to have a different Bill of Rights, like the Virginia Declaration of Rights, for your state to then limit the power of the coercive power of your state government. Okay? So we actually have a really lovely constitution in West Virginia, and which obviously originally derives from the Virginia one, as we were one state at one point. But if we didn't have the First Amendment, we would still have First Amendment rights against our government, because one of the First Amendment, which goes against the federal government, but this has also been interpreted technically through the 14th Amendment, which I'm not going to go into right now, but the 14th Amendment is what's called incorporated all these rights. Okay, so there's several clauses here, and I've color-coded them so you can see it more easily, but there's an establishment clause and a free exercise clause, and those are often in tension with each other. Because the establishment clause says the government shall have nothing to do with religion. And that's why we can't pray in school. Because people are different religions. And we saw in England what if you were a minority religion, which meant anyone who wasn't an Anglican. I mean, they talk mostly about the Catholics, but it also meant Baptists, it meant all these other Protestants. If you were not Anglican, then you were being discriminated against. And they put it in part because it became, the Anglican religion became the state church. So this was very important. On the other hand, they also wanted to have free worship. So you should be able to be Jewish, Catholic, Muslim, whatever you were, and still worship, and no one's saying you can't worship. But then you get into these really difficult, that's why they're difficult. And I notice people get really angry, but actually this is wonderful that we have, I don't always win on the Supreme Court when I want something to come this way. Like I want X to happen and negative X happens instead. But so what? That's the beauty of our country, is we can disagree, and we can disagree amiably and or amicably. And we can we have to understand that there's reasonable minds can make different rational choices about how do you balance those two things, because they're obviously in tension with each other. So should we allow religious schools to get public tax dollars go to them? Isn't that a violation of the Establishment Clause? If you want your kids to go to religious school, then you can pay for that, but the public schools can only provide secular education. You can supplement it with a religious school, right? But on the other hand, what about bus service? Is that fair that you're only giving busing to kids to go to public school but not to private school? So that's what it's about. I'm not taking a side on this. I'm just trying to explain what the issues are so you can understand it better. Speech in the press. That's another one that's interesting in that we often think that the press is horrible. We hear this all the time, but actually I really hope you'll think about this, is that, first of all, the press has their own clause. And the idea of the press is is to be a countervailing force against the government. And so we shouldn't, like when I hear them saying negative things about the government, I don't care. I research it to see if it's correct or if they're just bashing because they don't like them. But you can get, and this is another thing, you can get so much on media right now. You can find anything. You can find out that green Martians are currently running the government. And some people will believe it. Okay? And that's the problem, is that people are not doing their, you need, as a citizen, maybe we can talk about civic responsibility at the end of this. As a citizen, I think it's really important for me, not just, yeah, I read the news all the time, but I always say, I want to know, I don't make up my mind lightly. I read it and then see, is this true? And you try to, and that's hard. I understand you're busy, but if you want to be a citizen that really is part of this democracy, it's important to educate yourselves about these things. So I actually think it's really important to support the press, and if the press is intentionally lying, then we should hold them to when we think they're intentionally lying. Right to assembly and petition the government for grievances, that's obviously very important. This is all about protests. Again, protests are really important. It's when they're violent is this problem. So it's okay. Even, look, you don't have to agree with the message. In fact, if you had to agree with the message, they wouldn't need protection, right? You only need protection against unpopular speech, right? I don't like the Nazis. I don't, okay? But they have a right, if they want to say whatever they want to say, as long as they're not bringing guns out and using violence, then they can do those things, okay? So I think, you know, whatever you want, you can pick whatever you want, your favorite group or your least favorite group. You can talk about Black Lives Matter, you could talk about the Me Too movement, you could talk about the, the Proud Boys, whoever you want. And the reality is that that it's important in a democracy that dissenting voices are heard. What's also important is, and the government has a role to play in this, is to make sure that they're not violent. Okay, so these are just some landmark cases. I can give you these slides so you can look at it. These are the Tinkers. They had the black armbands for they were protesting the Vietnam War. And they were like thrown out of school for that, but actually it turns out that's symbolic speech. So that was unpopular for a lot of people. My family didn't love the Vietnam War, but we were always taught to always respect soldiers. And my family has been in different wars, but I think that's why for me it's not like there's no cognitive dissonance. You can be against a war, but also respect soldiers. So it doesn't bother me that they were protesting the Vietnam War, but obviously that could hurt a lot of people's feelings. They were coming out of the war and they didn't feel respected, and that's a very different issue. But even if that's an unpopular speech, or whether or not it's unpopular, it still is entitled to protection. We talked about the Second Amendment. Second Amendment, I just want to bring your attention to Heller and McDonald, because that has given people an individual right to own handguns. It doesn't talk about handguns in the Second Amendment. It just says a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. So again, you can see there has to be interpretation. You can't just look at this and say, oh, that means handguns. Because if you want to really be an originalist, wouldn't it just mean a bayonet? Right? So, and no one thinks that, or do they? So you have to, and again, I'm not saying that I believe that. What I'm saying is you have to understand that nothing is really an original interpretation. Nothing is textualist. There's always going to be interpretation. And that's okay in a society that is free. There is no case law at the Supreme Court level on quartering soldiers, but that's because no one would dare do it. There is one New York case from the Second Circuit, but no one's going to do that. The Fourth Amendment is basically you can't have searches and seizures without warrants, but that's also in schools. You can have warrantless searches for pot and firearms and things like that. In the schools, they have less rights, kids. But even in the workplace, you can search someone's desk. Now, remember, has to be government, right? Because the Constitution is all about the government. So this is only public employment jobs and public schools. The Catholic school down the road doesn't have to abide by the Constitution. Okay, it has to abide by other laws, but not the Constitution. All right. The Fifth Amendment has a grand jury clause. All crimes that are federal crimes have to have a grand jury. Double jeopardy. You can't be tried twice for the same crime, same federal crime. You can be tried for a federal crime and then a state crime. That's different. Self-incrimination, taking the Fifth Amendment. You're not allowed as a juror to then say just because they took the Fifth, that's evidence that they're guilty. Due process clause, which if you're interested, I'll tell you about, and the takings clause might be very interesting to West Virginians. That says that you can't take property without fair market value. Sixth Amendment is more criminal prosecutions, the right to a speedy trial, to be confronted with your witnesses. There's your confrontation clause. It has to be public. What I did was I color-coded it again, so you can see the orange is a public trial, the impartial jury is the gold, the notice of accusation is your green, confrontation clause, compulsory process, you have a right to call your own witnesses, that's your light blue or your blue. Then the two purples are competent assistance of counsel and self-representation. And there's been a lot of cases on this for speedy trials and things like that, and that's all in the Sixth Amendment. The Seventh Amendment is interesting. It says it gives you the right at common law to a jury, but it's pretty interesting because it doesn't apply to patent cases, for example. There's no jury trials for patent cases, and so it's sort of limited in some cases. Also, you can't read once the facts are decided. Those are the facts. Now, there's some exceptions to that. I'm not going to go into them unless you're interested in that. This is the last one I'm going to do, is the Eighth Amendment, which is, listen to this, excessive bail, excessive fine, cruel and unusual punishment, coming right out of the Virginia Declaration of Rights, okay? Then the Ninth and 10th Amendments are just about the enumeration in the Constitution of certain rights shall not be construed to deny other rights that the people have. The 10th Amendment is that the power is not delegated to the United States, go to the states or to the people. So again, I'm not going to talk about that because it's sort of technical. And the last thing I'm going to say is what's missing? What's missing that was in other things is a commitment to equality. So it's really a liberty revolution. Equality doesn't come until the 13th, 14th, and 15th, and 19th Amendments. So we have Reconstruction, and that has been something that is, I think, haunted us. And by the way, equality was meant for a small set. I always say a small set of white men. So it's not even all white men. It was propertied white men for the most part. So if you were, so it was still kind of in that almost Magna Carta idea that this is for the barons, but there's a little bit for other people. So you have to remember, I always try to remind students that things are getting better. Things were not perfect in the beginning. They're not perfect now, but they get better, and they don't get better in a straight line. They usually do stuff like this, but they overall are getting better. That doesn't mean you shouldn't fight for more, but I always try to remain optimistic. So we have a few minutes for questions. If you just want to put questions, a couple of things that Sean was thinking about is, Thomas Jefferson wrote about ordered liberty and the concept of civic responsibility that coupled the rights with duties. Should we care about civic responsibility? What is freedom? When does freedom infringe on other people's rights? You could be thinking about a mask requirement, things like that. Or if you just have any of your own questions, I can answer them if you want. So, any questions? I went fast, I know. Yes.
There's libel and
Slander, yeah.
Okay. Is there nothing that can protect us from the lies that are fed to us, either in the media or by government officials?
Well, interestingly, first of all, the internet, people are thinking of trying to regulate it like it's a utility. And that would be really good, because if you are a news channel, you do have to be regulated, and they do have to make retractions. And I'm pretty sure that there's part of Fox News is actually entertainment and not a news company. So that's why Fox doesn't have to make retractions sometimes. So I would like to see, we've seen the retractions on NBC and CBS and places like that. You don't really see it on Fox as much, and part of that is because they're not under the same rules. Part of them are. So I think if they're purporting to be news, I would personally like to see that government regulation on that to say you're a news agency, so you have to do your best. Obviously, look, reporters make mistakes all the time, and then they do their best to correct those mistakes, so we can't get upset because of that. I mean, we can, but we have to know that we're all human. But I think the internet is the real problem, and the internet doesn't want to be regulated, and they're very powerful, but eventually they will be, because the people are demanding it. It's just going to take time because they're so powerful. But right now, and that's why people are mad at what's his name, Zuckerman, because he's just irresponsible, and he is irresponsible. He wanted money, so he didn't care. He didn't care that foreign countries were paying to try to sway the election in different ways, some for this candidate, some for this candidate, and it's not right. And I think the other thing, though, I always say be smart. So yes, we're going to be fed things on the internet. I don't get my news on the internet because I know it's probably wrong and sensationalized. So we also just have to be smart about what sources we look at. I always go, if I look at something that's in the Washington Post or the New York Times, I don't just read it in the New York Times. I click on the link to the actual court document. I realize I'm a lawyer, so it's easier for me to read that. But at least I've read the document, and so that's something I think that people can do if they're really interested. And the other thing is, I always do read the BBC, because then you get the British view of us, which is not going to be pro-Democrat or pro-Republican. It's just going to be pro-them. So it kind of gives you a little bit more of a little more unbiased, because they don't have a bone to pick with either side, So, but that's what I think is the problem, and that's what I think has to happen, is in that case, the government has to sort of push back on the media. Yes?
The school board has been going back and forth on masks and quarantines and all of this.
Right.
Because the state dumped it in our laps, was really their job. And every time we do something, the next meeting we got the other side in there, raising hell with us because we did it. And the question is, to what extent is a low-level government agency like a school board responsible for public health decisions?
Yeah, that's a really good point, and I think it's been. You're right. The states are really responsible for masks and public health, not even the federal government. It's really the state, not the state local boards, not local government, the states. Although the federal government is responsible for coordinating everything, because we have this very difficult federal system. So, but the federal government can't get involved if it's only a state matter. So what the federal government should have been doing from the beginning is talking to all the governors and saying, okay, we have to coordinate, because if someone with COVID comes into this state, then everyone gets it in that state, right? The minute you have it in, right, it's spread. It's interesting. It's spread just like the plague. If you look at the maps, it came in through the plague comes in through the ships, and that's why West Virginia gets it last, right? The COVID comes in through the airports. It came in through California and New York and Chicago, and then it comes in. Okay, so and then to the major cities, it's exactly like the way the plague's done. So we really screwed up, and in some ways we did well, in some ways we screwed up from the beginning. And there's blame to go on both parties for this. So I'm just telling you my opinion. The problem is no one wants to work with each other anymore. That's the real problem. So it's like, when did masks become Republican or Democrat? I don't understand that. They're not. They're just about safety. And you can disagree about when a mask is no longer needed. But why aren't we listening to public health officials about that? I think West Virginia did a relatively good job. And part of that is because Justice was listening mostly to doctors and not to politicians. I don't think we did a perfect job, But if you look at what could have happened to us, because we have a very elderly population and we have obesity and we have a lot of diseases that were, and those were the groups that were, it was fatal, this disease is fatal for. And if you look at that compared to healthier states, we actually did pretty well. So I give us a lot of credit, but we still could have done better. And I don't understand why it's been politicized. And I think it's really a shame what's happened with the local school boards, because there's a lot of pressure from parents. Some parents are like, I'm not going to send my kid if there's no mask. Others say, you can't, masking children is child abuse. Really? Like both, like the whole thing, it's ridiculous that, it's the whole thing has become political instead of, wait, we have a public health problem. Shouldn't we talk about this public health problem? Or do you not care that this is going to, and it has killed a lot of people. Part of the problem goes back to what you were talking about over here, is some people don't even think it exists. And so if it doesn't exist, I don't know why you're living in the United States if you don't believe anything that's happening here anymore. So it's very hard for, for me, where I know my husband could die from this. But my students don't like wearing masks. They always do it because they respect us. But they don't like it. And they always, especially kind to me, because they know I can't be near them without a mask. And they've been very good to me. But it's because I always say in my classroom, I respect your opinions about this. It's a rule in the school. You have to have your mask on in class. If you don't have your mask on in the halls, you don't have to, but I'm not going to come close to you. And they're very respectful to me. But we have a non-political relationship of just kindness and civility. And I just hope that that's what we should be doing, instead of thinking, oh, I'm a Republican, I'm a Democrat, I have to do it this way. So that's my opinion about that. Other questions or comments? Or disagreements or anything?
Thank you.
Thank you. I so appreciate this audience so much.